Thank you all so very much for joining. My name is Ricardo Martinez. I'm the Executive Director for GLBTQ Legal Advocates and Defenders, also known as GLAD Law. Thanks for joining us on a Thursday afternoon, Thursday evening, about this important conversation about the cases that are impacting LGBTQ people that are before the Supreme Court this term. We've been holding these briefings regularly over the past year to talk about the legal issues and challenges facing LGBTQ people in this moment, to share information about what GLAD Law is doing to push back against these attacks in our communities, for you to have an opportunity to learn a little bit more about the people who are doing this work. So excited to be joined today by three of my colleagues from GLAD Law's legal team: Senior Staff Attorney Chris Erchull, Staff Attorney Sarah Austin, and our Legal Director, Josh Rovenger. If you have any questions, as we go through the information, you can drop any of those questions into the Q&A box, and we'll try to get to as many of those questions as possible. We are only able to provide general information tonight, so not any specific legal advice. That being said, if we don't get to your question, or if you are looking for more specific information, I encourage you to reach out to our GLAD Law Answers legal information line at gladlawanswers@gladlaw.org, or leave a voicemail at 800-455-GLAD. You can also go to gladlaw.org, and there will be an option for more information about that program. We are going to get started with Josh today. Josh is going to give us a big picture overview of what we were watching at the court that specifically relates to LGBTQ people. Josh, I'm going to turn it over to you.
Yeah, thanks, Ricardo, and thanks everyone for joining us tonight. So the Supreme Court has kind of a number of different work streams that it takes on each session. So I'm just going to kind of go in order of those different buckets. So kind of the first bucket of work that the Supreme Court takes on is their traditional merits docket. So, folks bring the case up for full review by the court takes full briefing, has oral argument, and, writes out a full decision. And there are a few cases there that we're really keeping our eye on, and I know we're going to talk about in more depth in a little bit. The first is Childs versus Salazar, which is a case about conversion therapy practices. The question in that case is whether a state, in that case Colorado, can protect LGBTQ youth from disproven conversion therapy practices by preventing licensed medical professionals from engaging in those practices. So that's, case number one. There was just oral argument on that 2 days ago. The other key cases that we're keeping our eye on the main merits docket are BPJ versus West Virginia and Little versus Hecox. And I think Chris a little bit later on is going to talk in more detail there. But those cases fundamentally ask whether a state's categorical ban on transgender girls playing sports violates the Equal Protection Clause of the Constitution and Title IX, the law that prohibits discrimination on the basis of sex in the educational context. So those are the main merits docket cases that we're keeping our eye on. But you also might have heard of this term called the shadow docket from the Supreme Court. And that is this emergency docket where a party can go to the Supreme Court in the middle of the case and say, we really need you to intervene immediately, otherwise we're going to experience some significant harm. And we've been seeing the administration take a lot of their cases up through this emergency docket. And on this docket, there isn't oral argument usually, there isn't full briefing, it's on a rush schedule, and we usually don't get a full written opinion. There's one case pending right now that we're keeping our eye on called Trump versus Orr. And that case relates to the ability of transgender people to get correct passports, essentially to have passports that match their gender identity. That emergency process has been fully briefed, which means the court could issue a ruling on that emergency petition at any time. We also expect, as we've seen since the beginning of this administration, that there'll be many other cases that might come up through that emergency docket. And so we'll be keeping our eye on that just throughout the year to see what else they consider there. Um, the then third bucket of work that the court takes on each year are just petitions for consideration to be heard. The Supreme Court doesn't have to take every case. They have pretty wide discretion on most of the cases that they take up for review. And so we keep an eye on cases that the court might take up each term. The most notable one, which I know we'll talk about later on, is one involving Kim Davis, who you all probably have heard of, the county clerk in Kentucky who didn't want to abide by Obergefell, the law on the Supreme Court decision on marriage equality. And then finally, we also expect that there'll just be a bunch of cases this term, both on the merits docket and otherwise, not specifically in the LGBTQ bucket, but implicating core separation of power questions and democratic institution questions. And all of those ultimately have implications for the LGBTQ community.
Thanks, Josh. A lot of people are pretty pessimistic about how the court has been ruling recently. And we got some tough rulings last term. What is your general sense heading into this term?
Yeah, I mean, I'm not going to sugarcoat the makeup of the Supreme Court. We've had rough decisions from that court for the past few years and have a tough ideological split on that court. What I can say is while there's certainly an uphill battle on some things that progressives care about, there are also really strong arguments in the cases that I just mentioned in particular, and really consistent views by the courts that have considered these questions. And so, while there certainly is a tough Supreme Court that we have to grapple with and have to be strategic about in how we approach, there are also, compelling arguments to present before them. I'd also note, though, kind of two bigger picture pieces on that question. The first is, the Supreme Court isn't everything. Only a limited number of cases actually get up to the Supreme Court each term, and that includes even in the context of lawsuits challenging policies from this administration. Some counts have it at about 200 cases that have been filed against the administration overall, and about 20 of them have gone up to the Supreme Court in one capacity or another. So, not to push back on the question, but, the Supreme Court is only a piece of the puzzle here. The other thing I would note is one of the hallmarks of the Roberts Court in many of the cases, although, not always, is that they tend to take a narrow path in their decisions. And so even in instances where we ultimately get an unfavorable outcome, there is a trend by this court to doing so in kind of the narrowest way that's possible, which ultimately leaves open a lot of paths for us to still pursue depending on the specific issue.
Thanks, Josh. I think you can push back on any of the questions. I think that is totally fair. When we ask folks to register for this, we allow them oftentimes an opportunity to submit questions. And obviously we have our Glad Law Answers line. And I know a lot of people who joined us tonight are wondering about the emergency petition in the Orr v. Trump case regarding the ability for transgender people to get correct passports. Can you tell us a little bit about the status of that case?
Yeah, so just to step back for a second and put that in context, for over 30 years now, across 5 different presidential administrations, individuals have been able to get passports that align with their gender identity. And for the past several years, individuals also were able to get an X marker to designate their sex on their passport. Then this new administration came in January as part of their broader approach and strategy towards targeting the transgender community, reversed that policy and said, no, the sex that's on your passport has to be the sex that you were assigned at birth. In other words, the administration adopted a policy that deprives individuals of a usable ID document that allows people to travel safely. And individuals sued our coalition colleagues at the ACLU and others or other partner organizations sued. There's a class challenging that policy, and the district court enjoined the policy. They said it was unlawful and couldn't be applied because it was not only unlawful, but increased an individual's risk of harassment and violence when they traveled. So the Trump administration first went to the First Circuit Court of Appeals and said, we really want to administer this policy while this litigation moves forward. And the First Circuit said, you don't have a good basis for that argument. We're not going to allow that. And now the government has asked the Supreme Court for emergency relief during the litigation itself, saying, we want to be able to enforce this policy while the litigation is ongoing. The Supreme Court, though, has not yet ruled, as I mentioned before, on that petition. And so for the time being, because of the injunction, individuals can still apply for passports under the old rules. So getting a sex marker that matches their gender identity.
Thanks for that, Josh. I think we're going to turn over to Sarah and move to a case that the court just heard arguments in this past week. Sarah, can you tell us a little bit about Childs versus Salazar and what it's all about?
Yeah, thanks, Ricardo. And Josh, as Josh already highlighted, the case is about whether states can pass laws that protect minors from dangerous, ineffective, and misleading healthcare practices. And in this case, that's conversion therapy. And I'm going to get really into what conversion therapy is and how it works. But before I do that, I just want to acknowledge we know this is a really painful issue, and it's hard for those who have experienced it or who know folks who have experienced it to talk about and hear about. So I want to be sensitive to that. And if, whatever you need as you listen, take your time, take a step away if you need to, take care of yourselves. So conversion therapy, I think many on the call will know, is a debunked and discredited practice. And what it does is it tries to change a person's sexual orientation or transgender identity. And this practice has no basis whatsoever in science or medicine. Studies have shown that it does not work, and it predictably traumatizes young people who go through it and their families and their entire communities. So Colorado recognized these harms, and in 2019, they passed a law to protect minors from this harmful practice. Now, a licensed counselor named Kaylee Childs is suing the state of Colorado, and she's represented by an organization called Alliance Defending Freedom, which regularly files lawsuits seeking to limit legal protections for LGBTQ people. And in this case, Childs and Alliance Defending Freedom are saying that she has a First Amendment right to practice conversion therapy. And that means the core of her argument is because she's doing talk therapy, she's engaged in pure speech that's subject, and any regulation of that speech is subject to strict scrutiny, which basically means it's generally not going to be subject to state regulation. And she thinks she has a free speech right to provide this dangerous and ineffective treatment.
I feel like we all need to take a breath after that. But I know that you can't predict the future, but what could the impact of the court's ruling be?
Well, if the court accepts Childs' argument completely that talk therapy is pure speech, that's going to jeopardize similar laws that prohibit conversion therapy and protect minors in more than 20 states. And so this ruling could potentially put young people in those states in danger. And when you think about this and the impact, it's really important to understand that there's broad bipartisan and religious support for laws that protect minors from conversion therapy. And that makes sense because everybody wants kids to be healthy and safe. And all families need to be able to trust therapists and healthcare providers to help their children and not hurt them.
That's right. GLADlaw filed a brief with the court that shared stories from families who have been really hurt by conversion therapy practices. Can you share a little bit about that? And thank you for doing that work and holding space for those courageous folks who shared and uplifted their stories.
Thanks, Ricardo. Yeah, we're so honored to file this brief. It told the stories of 8 survivors who grew up in religious families and they went through conversion therapy as young people to change either their sexual orientation or their transgender identity. And in telling the stories, a few clear themes really emerged. The first one is conversion practices filled them with shame and with guilt. And many of them talked about how their therapists encouraged them to hate who they are. And unsurprisingly, they came away from this so-called treatment with depression, anxiety, and suicidal thoughts. You know, they came away much worse than they came in. And another theme that came out was these practices really tore their families apart. And the way that it did that is therapists often blame their parents for making them gay or making them transgender. Some of the people whose stories we told were counseled that their mothers were too loving or their fathers were too distant. And a lot of times there was just no basis in reality for that. But these young people were in a really vulnerable place and they trusted their therapists who were in positions of power. And they, were kind of turned against their parents, and it really divided families, even when they were really loving and really stable. And a lot of the parents came to regret ever seeking out this therapy in the first place. And the third theme that I want to highlight is a lot of the young people, or a lot of the people I spoke to as young people, had started out really enthusiastic about conversion therapy because they had deeply held religious beliefs and they thought this therapy is going to bring me closer to God. But what really happened to them was they were traumatized by the experience and they weren't able to separate that from their faith or from their religious identity. And the whole thing ended up driving them totally away from the faith communities that had given their lives purpose and meaning. And some of them never were able to go back. So I think these themes speak really clearly through one of the stories. So I want to just share briefly what, the story is for one of the amici or friends of the court that we represented. His name is Matt, and he was subjected to conversion practices when he was a teenager. He grew up a devout Mormon and he was in a really tight-knit family, and he loved his family so much. And he hoped that conversion therapy would keep him close to his family and help him live by his faith. But what ended up happening was it had the opposite effect. His parents felt really demonized by the therapist and shamed by the therapist because they were being blamed for making their son gay. And Matt felt really depressed and really isolated in the family. He didn't really know who he could talk to anymore because his parents were ashamed and afraid and angry, and so was he. And his sister told him later when he became an adult that the whole experience of conversion therapy brought darkness into their family home. And his parents ended up regretting putting him through it. And even though they've been working together for more than 20 years to repair the family relationships that were broken by conversion therapy, they're still working to heal those family bonds. And I think this story really shows why it's so important for states like Colorado to protect families from conversion therapy practices, because they're so dangerous and they isolate kids and scapegoat parents and divide families, and nobody deserves that.
Thanks for sharing that story, Sarah. I know that you listened to the argument from Tuesday, coming out or after finishing listening to the whole thing. Do you have any thoughts coming out of that?
Yeah, I think a few things from the argument were really striking. And the first one is the false framing that this case is based on. Childs and her legal team are basically arguing that Colorado's conversion therapy law is illegal because it's picking a side in a culture war. They're trying to say that Colorado wants to help LGBTQ kids and not religious kids, and that just couldn't be further from the truth. Colorado's law is a really narrow prohibition, and it's focused on one specific mental health treatment that is dangerous, ineffective, and misleading to the families who seek it out. The law doesn't prohibit therapists from honoring their clients' religious beliefs. It doesn't prohibit therapists from supporting clients as they work through challenging issues related to sexual orientation and gender identity. And there are multiple therapeutic modalities that actually do this in a clinically appropriate way and try to help people navigate their religious identity, their sexual orientation, and their gender identity. And all of those clinically appropriate modalities are still totally available. the only thing the conversion therapy law regulates is this harmful practice that seeks a predetermined outcome of change, which again doesn't work and is super dangerous. So this is all to say it's not a culture war issue. It's about protecting vulnerable young people from demonstrated harms. And if anyone has taken an extreme position, it's Childs and it's her legal team, because their argument that talk therapy is pure speech that is basically not able to be regulated by governments, that would effectively prevent states from being able to prohibit all forms of talk therapy that might be harmful. And it might even insulate harmful medical advice from state regulation. The example I liked from argument was Justice Kagan saying, you know, a doctor telling a patient with high cholesterol to go eat dessert for every meal and saying that would help. That's like what we're talking about here is she's saying if it's words, states can't say anything about it. And that is a really extreme position. So, you know, at this stage, we can't predict how the justices are going to decide the case. We can't predict what their reasoning is going to be. You know, some of the justices did actually seem sympathetic to the free speech arguments that Childs and her legal team were making. But at the same time, the lawyer for Colorado clearly spoke to the harmful impact of conversion therapy on young people and families, and clearly spoke to the state's place in regulating that practice to protect kids and families. So we hope that with reflection, the court's going to understand the very real need to protect minors from this abusive practice and uphold Colorado's law.
Thanks, Sarah. I'm going to give you a break for a little while on questions, and we're going to turn to Chris. Chris, the court is also addressing other issues impacting LGBTQ youth. Can you share more about BPJ and HECOX?
Yeah, so this term, the court's going to hear consolidated cases out of Idaho and West Virginia about state laws, a new kind of state law that just popped up in the last 5 years, state laws that put categorical bans on transgender girls participating in girls' sports. So these cases, BPJ versus West Virginia and Little versus HECOX, these represent the first time the court will directly address whether states can exclude transgender students from school sports teams. We have to remember how essential sports are as an educational opportunity. Sports in school are a critical way for young people to build character, to learn about leadership, cooperation, self-discipline, communication, even integrity. And the Supreme Court's poised to decide whether transgender students have the same right to these essential learning opportunities.
Thanks, Chris. What have the lower courts been saying about these categorical bans thus far?
Well, at the core of these cases is whether a blanket ban excluding transgender girls from girls' sports teams violates their rights under Title IX and the Equal Protection Clause of the US Constitution. In both the West Virginia and Idaho cases, the lower courts struck down these bans, concluding that yes, fair competition is a legitimate concern for the state legislature, but excluding transgender students in all circumstances does not advance fairness. It's discriminatory and it inflicts real harm on transgender girls, like the plaintiffs in these cases.
GLAD Law secured a preliminary injunction against a similar categorical ban in New Hampshire. What are the impacts of these bans?
Yeah, these bans do more than just deprive transgender girls of opportunities that sports programs provide to students. They also stigmatize and isolate transgender young people at a time when they are already experiencing so much stigma. Last summer, August 2024, our client Parker wore her soccer practice clothes to the courthouse because she had to wait for a judge to decide if she could go to practice. And she wouldn't have time to go home and change after. Other kids don't have to stop at court on their way to practice and hope the judge is going to let them play with their friends. That moment made for some really great photos, but it also really illustrates how hard it can be for transgender young people when they're the center of a political firestorm. And of course, these bans on transgender girls ultimately are harmful to all girls. The bans open the door to really intrusive sex verification processes that can target any girl whose appearance or athletic ability doesn't conform to stereotypes about what girls should look like or how they should perform in sports.
Thanks, Chris. That is really heartbreaking. As you were talking, it's kind of hard not to visualize Parker being in court, ready to play, and having this obstacle, right, from being able to just participate with her friends. What do you think is at stake in the case before the court this term? Could it have a broader impact beyond sports?
Yeah, unfortunately for the transgender community, the stakes really couldn't be any higher. More than 20 states have enacted similar bans like this in recent years. And any ruling that upholds these categorical exclusions would essentially greenlight discrimination against transgender youth in one of the most formative aspects of school life. But the case also threatens to overturn really important precedents that have protected access to restrooms and other school facilities, activities, programs for transgender students.
Sorry for the delay between when Chris ends and when I start talking. I have to come back and unmute myself. So if there is a pause, just know that I am paying attention actively and just trying my best to get to the unmute button. Thanks, Chris. Gladlaw is not representing the plaintiffs in this case, but we are submitting a brief, just as Sarah mentioned, like we did in Childs. Can you talk about what role those Friends of the Court briefs play in cases like this?
Oh yeah, for sure. Amicus briefs serve a number of really critical purposes. You never know if you're actually going to be able to persuade any of the justices with good arguments, and we really can't afford to leave anything unsaid. But this is true for the majority opinion in any case, but it's also true for dissenting opinions or concurring opinions. History is full of examples of how a dissenting opinion eventually became the rule of law. And we want to make sure that we do all we can to equip all of the justices with the best information and the best legal arguments. And we also have an obligation to do everything we can to minimize the harm of any potential bad ruling, which is what a lot of the BPJ briefing is going to be about. We have been working with others in the movement to ensure that the best array of briefs possible will end up before the Supreme Court, so that even if the ruling is not favorable, and of course, we really hope that it will be, but even if it's not, we want the justices to be aware of how dangerous it can be for there to be a broad ruling. Another goal of amicus briefs is to help with public education. You know, we share these briefs with journalists and with the public, and we need to help people understand these issues just as much as we need to help the justices. Finally, we also really need to provide future advocates with the tools they need to continue the work into the future. We are laying really important groundwork for a future that we believe in, a future where the Supreme Court will eventually understand the fundamental promise of our Constitution to protect the most vulnerable people among us.
One final question before I turn it to Josh to talk about the Davis petition. What are you hoping the court really considers in hearing this case?
Well, honestly, for me, I hope the justices take a close look at the plaintiffs in these cases, like Becky Pepper from West Virginia or Lindsay Hecox from Idaho, Parker and Iris from New Hampshire. I hope that they recognize the humanity of these girls and understand that not one of them is a threat to anyone, not one of them is trying to take anything away from any other girls. Gladlaw has been working for years to reframe the sports debate, and we really need to, because the current framing, it's a trap. The political landscape makes it seem like advocates for transgender equality do not care about fairness in women's sports, as if equality and fairness are opposing goals, but they're not. The states that are defending these bans present the issue as like an either or. You exclude all the transgender girls from sports, or you ignore all the considerations about fairness and safety. This is a false framing, and it obscures the truth, which is that everybody wants sports to be fair and safe. Blanket bans do not achieve these goals. Being transgender does not mean that someone poses any type of competitive threat or safety risk. Assumptions and stereotypes about an entire group of students are not an accurate way of assessing athletic ability or competitive advantage. And allowing politicians to make these kind of blanket stereotypes, it really sets a dangerous precedent. Finally, I just want to say there are so few transgender teenagers enrolled in sports programs in America's public schools. It's really unusual and frankly outrageous for state legislatures to be passing laws that impact so few people. And it's really totally unclear why the Supreme Court needs to weigh in on this issue. But I hope the justices are able to stay focused on why we have discrimination protections in the first place, which is to protect extremely vulnerable people like transgender girls who are, just teenagers trying to go to school like everybody else.
I had said that there was that was the last question I was going to ask you, but someone prompted me in the chat that there is one more question for you about Ludlow. So let me just go and double check so I can read it while we're on topic. I don't see it, so I'm going to move on to Josh, but if somebody could raise that question for me in copy and paste it, I will come back to Chris in a minute. Josh, earlier this summer, the court was also asked to review a case that involves marriage equality. That's the case of Kim Davis, the former Kentucky county clerk who refused to grant marriage licenses to same-sex couples and ordered her entire office not to do so. And while she asked the court to overturn Obergefell, the National Marriage Equality ruling Gladlaw argued and won the Supreme Court in 2015. We don't have any real reason to think they will take that case. Is that right?
Yeah, I think that's right, Ricardo. And I think the context here is really important to explain why, because it really is just an unusual case with unusual circumstances. So, as you alluded to, stepping back to a decade ago, 2015, Gladlaw's own Mary Bonato argues before the Supreme Court. Supreme Court issues this decision saying marriage equality is the law of the land. Kim Davis, who ran for office to a position to issue licenses in accord with the law, refused to abide by Obergefell. At the time that she refused to do so, Obergefell was very clearly the law, and she went out of her way not only to refuse to personally issue those marriage licenses, but to get everybody else in her office to not issue those licenses as well. And so one couple came in to get married and the office turned them down on multiple occasions. So they sued her for emotional distress damages because, if you go into the briefs and read some of the testimony in the case, it's extraordinarily heartbreaking, the experience that these people went through and how dehumanizing they experienced it because this person had taken the law into their hands. So they sued, sought emotional distress damages, and a jury of their peers awarded them emotional distress damages. So that's the background of how this case has emerged. And Kim Davis now 3 separate times has appealed this case at various points to the appellate court and previously up to the Supreme Court. And previously on the prior go around, the Supreme Court didn't hear the case because even the more conservative justices explicitly recognized that it just was not the right vehicle for addressing marriage equality questions. And the Sixth Circuit, each time that she's brought up this case has ruled against her because, taking the law into your hands in that way just implicates a whole bunch of other questions across a whole range of issues. And so even very conservative judges, including Judge Riedler on the Sixth Circuit, said as much in this very case. And so, with fewer than 60 to 80 cases that the Supreme Court takes each year out of the thousands or so that the Supreme Court is asked to take each term, it really just wouldn't make any sense for them to take this specific case, given these highly unusual facts and the other issues that it implicates. even putting aside the question of whether any of the justices are interested in relitigating Obergefell.
We won't know for a while whether the court is going to hear the Davis case at all, but Glad Law is prepared to defend marriage equality legally. Can you talk a little bit more about that?
Yeah, so I wasn't, at Glad Law back in 2015, but talking with Mary and other colleagues, my understanding is the decision came down and the team immediately started focusing on how do we defend it. So we've never taken our eye off the ball. And in fact, just a few years ago, since 2021, we've actually had a dedicated team within Glad Law that is focused on marriage equality and ensuring that it is protected and remains the law of the land. So, we closely monitor developments across the country. We connect with partner organizations and attorneys on the ground. We do extensive research to ensure that we're ready for anything that might come our way. So, there's many reasons why the court shouldn't and retake up this question. And we're doing what we can to ensure that the court understands the implications of taking up the question, but we're also ready to go if the court ever decided to reconsider marriage equality.
The last question before we turn to some of the questions that people have been so patiently waiting for us to tackle. What would you encourage people listening to do if they are worried about what the court will do or any other threats to marriage?
Yeah, so one of the most important things that led up to the marriage equality decision was people seeing queer families and getting to know their queer neighbors. And I think it is as true now as it was then that the personal connection and the personal stories are just so critical. What we've seen since Obergefell is that marriage equality hasn't just been good for queer couples, it's been good for kids, it's been good for businesses, it's been good for society at large. And so, if you're worried about marriage equality, the biggest piece of advice that, I would convey is have conversations with people, talk about how marriage equality has impacted your life or those that you love, because it really, has been just a boon to our country since 2015. And, public support for marriage equality, I'll say, remains very high. There remains bipartisan support for marriage equality, and all of us can do our part in maintaining that high level of support.
Thanks, Josh. Before we open it up to the other questions we had for the entire panel, I just this one's addressed to you, Sarah, but obviously anyone feel free to weigh in if you have things to add. Going back to the Child's case, by claiming talk therapy is not treatment, but rather free speech, are there other implications for issues not even in the gender or sexuality realm? Are there any state laws that ban gender affirming talk therapy, or would those bans be struck down as well?
Yeah, that's a really good question. Thanks for raising it, Ricardo. I think at this point it's really hard to say since we can't predict how the justices will decide the case or what their reasoning will be. There are a lot of different paths they might take. So I don't want to answer definitively, but like in theory, yes, there could be broad implications for talk therapy outside the gender and sexuality space. And there could even potentially be implications for routine medical advice if it's delivered through words. But like I said, we're kind of hoping that the court reflects carefully on these issues and comes to a reasonable decision that's going to protect young people from harmful conversion therapy practices. And happy to chat more offline about that as more questions come up.
Before I ask the next question, anything to add, Chris or Josh? Okay, Chris, this was directed to you, but open to all three of you. There's another school-related case that might be before the court this term, Foote v. Ludlow out of Massachusetts. What is that case about, and what is its status?
Wow, yeah, this is a case that Glad Law has been involved with from its very beginning. The story is really unique, but it has a lot in common with a lot of other stories that we have heard across the country in recent years. A student goes to school, has a conversation with school personnel, and says, "Hey, I'm nervous to tell you this, but I want to try out a new name and new pronouns while I'm at school." And look, most good teachers, counselors, or administrators are going to respond in the same way and just say, "Hey, how can we support you here at school?" That's the first question. And then, is there anything we can do to help you have this conversation at home? And what happened in Ludlow followed this basic pattern. School personnel did not feel like it was their place to call the parents, talk to them about the student's request. But as you might expect, parents often eventually find out this kind of information anyway. And in this particular case, the parents are suing the school district, claiming that their rights have been violated. Well, the district court judge dismissed the case, and the First Circuit upheld the dismissal, explaining that courts have never, ever recognized a constitutional right for parents to demand that schools monitor and report back about how kids are expressing themselves while they're at school. That right's never been recognized, and for really good reason. It would be impossible for teachers and other school staff to look out for all the different ways that young people experiment and come to terms with their identity while they're at school. And to call parents and to tell parents every time they think that parents might want to know about what students are thinking and saying and how they're expressing themselves. Well, the Alliance Defending Freedom, ADF, has petitioned the Supreme Court to review the First Circuit decision. So right now we are waiting to see if the Supreme Court might take this case up this term, maybe next term. We don't think there's any reason that they should, of course, because no such constitutional right has ever existed or been recognized in it. But yeah, it's something we're definitely watching closely.
Thanks, Chris. One more question before we turn to the remaining questions that we had. There's a question that is open from someone who's joining us who would like an update on the trans-military ban, particularly Talbot v. USA.
Yeah, I'm happy to jump in and give this update. As you likely know, earlier in the year, just for level setting for everybody, we filed suit against the administration's ban on the ability of transgender individuals serving in the military. These are folks who are patriotic and brave and who have for decades, for many of them, served their country with distinct honor. So we sued, we obtained a preliminary injunction in that case blocking that executive order from going into effect because, as the court explained, the executive order was dripping with animus against the transgender community. There was a companion case that our coalition colleagues filed against the ban as well. They also obtained a preliminary injunction. The government in that case, in that emergency docket I mentioned before, took the military case up to the Supreme Court. And in an unreasoned order, the Supreme Court said this military ban can go into effect during the litigation. So at least right now, that ban is in effect, and the different branches of the military have started taking steps to discharge transgender military service members. In our case, so we obtained that preliminary injunction. The government has appealed that preliminary injunction to the DC Circuit Court of Appeals, one of the courts that's right underneath the Supreme Court. And we're in the process of briefing that appeal up to the Supreme Court. So that is moving forward. We still have the full actual litigation to move forward in the trial court, which will involve us further developing the factual record before that court, and moving for ultimate judgment in that court. So kind of bigger picture, all of that is to say The litigation is still moving forward, notwithstanding the Supreme Court's order, which has allowed the ban to go into effect. That is just an interim order. There is no final judgment in the case, and we have every intention of continuing to build the factual record to further show just how animus-driven that executive order was and how unlawful that was.
Josh, I wonder if you could talk a little bit about GLAD law's work in the federal courts and how they're still a powerful backstop to government overreach and attacks on civil rights.
Yeah, for sure. So I think, the news covers the Supreme Court a lot. I think we'll see story after story of the Supreme Court doing this and the Supreme Court doing that. And I don't want to downplay the actions of the Supreme Court and the real harm that a lot of their decisions and emergency actions have caused over the past few years. But as I mentioned, at the top of the webinar, the Supreme Court is just part of the bigger picture. Right now, depending on which tracker you look at, there's around 200 or so cases against the Trump administration. Of those 200, only about 20 of them have gone up to the Supreme Court thus far, which means the vast majority of cases that are challenging administration actions aren't getting up to the Supreme Court. And a significant number of those, the courts are holding the Trump administration accountable and ruling against the policies that the administration is taking. At least 3 of our cases I think are prime example of this. So after the administration came in, they issued this executive order that, among other things, would have ordered the Bureau of Prisons to move transgender female inmates from female facilities to male facilities, putting them, as all of the research and as history tells us, into an extremely dangerous situation. We sued on that, and as a result of our lawsuit, we've been able to obtain preliminary injunctions on behalf of nearly every transgender female inmate currently housed in a female facility, requiring the government to keep them within those facilities. Sarah has been a critical leader in moving that work forward and in securing the security for our clients there. The government has appealed that preliminary injunction to the DC Circuit, but they haven't to date taken that matter up to the Supreme Court. And so to date, all of those individuals are protected by the court orders that we obtained, which is having a real practical impact in their lives and on the ground, and a practical impact in showing that the administration's unlawful actions can be declared unlawful and enjoined during the litigation. The other piece I want to add, just because, I think we all recognize that, there is we have an uphill battle with the makeup of the Supreme Court. And so I don't want to downplay, the damage that the Supreme Court has done over the past few years or could do, is even in those cases where the Supreme Court hears the matter on the merits and rules against us, there's still a lot of short-term and long-term benefits. So, we're stopping harm in the short term and delaying harm. So the Orr case that we talked about before, there's this period right now because of the orders that are in place where individuals are able to obtain passports that are consistent with their gender identity and can use those passports, moving forward. The work is also critical to broader narrative building. Lawsuits are important to vindicate rights. They're also critical to shine a light on an issue and often do so in a way that a news story can't do on its own. And so what we found with our litigation, such as, our lawsuit that Chris has been leading, challenging the executive order that targets trans kids who just want to play sports. The lawsuit itself, the mere fact of the lawsuit, can really be an impetus to change the public narrative on an issue. And then, finally, facts matter. Maybe, in the short term, they matter to courts. in the long term, they matter to proving to, history that, number one, there is a historical record of people who fought against what this administration was doing and established the facts to show exactly what the administration was doing. And then two, to serve as the basis for a change in policy or a different understanding of what the law is in the future.
Thanks, Josh. Beyond the courts, I think we can all recognize that we have power as people. What would each of you share about what we can do as individuals and communities to protect LGBTQ plus people's rights and advocate for the world we want to see? And that's open to all of you.
I'll go ahead and go first and say, the advice I always give everybody, if you want to be politically engaged, if you want to be politically minded, a good place to start is your local school board or school community. Be aware of what's happening there, because so much of this attack on transgender and gender nonconforming young people is starting in school board community settings, and you can actually have a huge influence if you're paying attention, if you're willing to show up and go to bat for kids who really need your support. That's my number one advice.
I guess I'll jump in next and say, first, vote in every election that you can vote in. And second, do anything else that you can that you will keep showing up for. I think every single person on this call has their own unique strengths, their own story, their own skills, their own things that give them joy, and find a way to use those things to advance the work and build community, because we all have that duty to each other, and it really takes all kinds.
And I'll kind of pull threads from both of those responses and say, again, just have conversations with folks about the issues that matter to you, and do it in a way where you approach it with patience and grace and curiosity. Meet people where they are and just hear their concerns about the issues you care about and talk with them, because at the end of the day, it's the individual to individual interactions that can really move the needle in deep ways. And then I'll also say, I'll pick up on Sarah's vote in every election with run for office. Doesn't matter your political party, do not care. Run for office everywhere. Run for office for every position that's open. And if you don't yourself want to run for office, get someone you care about to run for office and support that run for office.
And just further pulling that thread, I think this is a time to be incredibly generous and donating to organizations like GLAD Law, but also small organizations that are championing this work in a really hostile landscape. I think money goes a long way for high impact organizations that are focused on the grassroots organizing and policy and advocacy work that really is life-saving and can really change hearts and minds with the conversations that they have, showing up for our community on behalf of us. Thank you all for joining us. We're going to leave it there. Thank you, Josh, Sarah, and Chris. And thank you all again for joining us one more time. We'll be monitoring all of these cases and sharing more information throughout the year. I encourage you to check out our website at gladlaw.org. Make sure that you are on our mailing list and follow GLAD Law on social media to keep up with the latest information, including when the next community briefing will be held. If you have any specific questions about your specific situation, you can reach out to gladlawanswers.org. All of the information, including the email and the phone number that I mentioned at the beginning, will be available there. And if you're looking to get more involved, we have information about how to do that as well, including, as I mentioned before, donating to support our work in the courts and legislatures to protect LGBTQ people. Thank you again. Take care of yourselves and each other, and have a good night.